Before we jump in, I do earn a referral fee when you use the services and companies I demonstrate in the video, but there is no additional cost to you. I chose them because they're the best in the industry and you're safe with them.
Have you ever wondered how to put property in a trust? If you have, you're in the right place. We're going to kick things off by understanding what a trust is and why it's so important. A trust is a legal arrangement where one party, known as the truster, transfers property or assets to a second party, the trustee. The trustee then manages these assets for the benefit of a third party, the beneficiary. It's a bit like passing a baton in a relay race, but with legal paperwork and potentially significant financial implications. Now, there are two main types of trusts: revocable and irrevocable. A revocable trust is like a flexible gym membership. You can change, modify, or terminate it at any time during your life. On the other hand, an irrevocable trust is more like a contract set in stone. Once you've set it up, you can't easily change or terminate it without the consent of the beneficiary. So, why would you want to put your property in a trust? Well, there are several compelling reasons. First off, it can help you avoid probate, which is a time-consuming and often costly legal process that occurs when you pass away. Secondly, a trust can save you on estate taxes. Think of it as a legal loophole that lets you keep more of your hard-earned wealth in the family. And thirdly, a trust gives you control over your property even after your death. It's like having a hand in the future, guiding how your assets are used and who benefits from them. In essence, a trust is like a treasure chest for your assets, locked by legal terms, guarded by a trustee, and eventually opened for the beneficiaries. It's a strategic tool that can provide financial security and peace of mind for you and your loved ones. Now that we understand what a trust is and its benefits, let's delve into how you can put your property into a trust. Stay tuned, because we're just getting started. First things first, you need an attorney, but not just any attorney. You need a competent one with experience in estate planning. Why is this important? Well, the process of putting property in a trust isn't a piece of cake. It's laced with legal jargon that might be a bit challenging to understand on your own. Your attorney will be your guide, your interpreter, if you will, making sure you don't miss a beat. They'll help you draft the trust document, ensuring every I is dotted, every T is crossed. They'll ensure that the trust you're creating is not just valid, but legal too. They'll be the ones to navigate the choppy waters of estate laws so you don't have to. Remember, your attorney is your partner in this journey. Their expertise will be invaluable in making sure your trust is set up properly. With a competent attorney by your side, you're ready to move to the next step. The next step is drafting the trust document. Now you may ask, what exactly is a trust document? Well, it's the legal piece of paper, the linchpin that holds everything together. It's the written agreement that establishes the trust, outlining who's involved, what's included, and how it's all going to work. So let's delve into the main components of a trust document. First up, we have the grantor, also known as the settlor or truster. This is the person who creates the trust, the one who's putting their property into it. They're the ones who set the rules of the game, so to speak. Next, we have the trustee. The trustee is the person or entity responsible for managing the trust, according to the rules set out by the grantor. They're like the captain of the ship, steering it in the direction the grantor has charted. Then come the beneficiaries. These are the individuals or entities who will receive the benefits from the trust. They're the ones who stand to gain from the trust's assets, whether that's now or in the future. Now, it's crucial to ensure that the trust document is crystal clear. Unclear or ambiguous language can lead to disputes down the line, so it's worth spending the time to get it right. It's like building a house. You wouldn't want to rush the foundation, would you? The trust document should also be comprehensive. It should cover all the relevant details, such as the terms of the trust, what happens if a trustee can't or won't serve, and what to do in the event of a dispute. It's like a roadmap for the trust. The more detailed, the better. One more thing to remember: the trust document isn't set in stone. It can usually be amended or revoked, depending on the type of trust and the terms set out by the grantor. So there's room for flexibility, for adjusting to changing circumstances. With the trust document drafted, we're ready to move to the next step. Now, it's time to transfer the property into the trust. At this stage, you're not merely moving your property into a trust, but you're essentially redefining its ownership. A new deed is created, which marks the trust as the new owner of the property. This is a significant step as it involves changing the name of the owner from your name to your trust's name. This process is crucial, and here's how it works. You'll need to draft a new deed for the property. This deed will be somewhat different from the original one. Instead of having your name as the owner, the new deed will have the name of your trust. The creation of a new deed might sound complicated, but don't worry. Your attorney will guide you through this process, ensuring that the deed is properly drafted. They'll help you to fill out the necessary paperwork and make sure that everything is in order. Now, once the new deed is ready, it's time to make it official. This is done by signing the deed in front of a notary. A notary is a third-party witness who verifies that the signing process is done willingly and under no duress. After the deed is signed and notarized, it's not yet time to celebrate. There's one more step: recording the deed. The deed must be recorded in the county where the property is located. This is an important step as it makes the transfer of ownership public record. This process might vary slightly from county to county, but generally, you'll need to take the notarized deed to the county recorder's office. They will record the deed, making the transfer of ownership official and recognized by the law. Remember, transferring the property into the trust is an essential step in setting up your trust. It's not something to be taken lightly or rushed. Make sure you understand each step, ask questions if you're unsure, and always follow the advice of your attorney. With the property transferred, we're almost at the end of the process. The final step involves storing the trust document. This piece of paper might seem unassuming, but it's the key to your entire property trust. It outlines who gets what, when, and how, making it an essential document that needs protection. Keeping the trust document in a secure place is paramount. You could consider a safe deposit box at a bank. It's a solid option, offering robust security and peace of mind. Alternatively, your attorney could keep the document in their office. They're well equipped to handle such important documents, and it could be convenient for any future legal needs. But don't forget to keep a copy at home too. It's always handy to have quick access for reference, or in the event of an unforeseen circumstance. And there you have it. With the trust document safely stored, you've successfully put your property into a trust. Now, you can rest easy knowing your assets are well protected and in good hands. Let's quickly recap the steps involved in putting property into a trust. We've journeyed through the process together, unraveling the intricacies and revealing the simplicity that lies beneath the seemingly daunting task. Firstly, we emphasize the importance of hiring a competent attorney. This professional guides you through the legal labyrinth, providing sound advice and ensuring that your trust meets all legal requirements. Remember, it's not just about getting any attorney, but finding one who specializes in estate planning and trust law. Their expertise will make the process smoother and more effective. Next, we explored the drafting of the trust document. This isn't just a piece of paper. It's a legal blueprint that outlines the operations of your trust. Your attorney will help you draft this document, making certain that it clearly states the trust's purpose, identifies the trustee, and describes the trust property. Then, we moved on to transferring the property. This is where you officially move the ownership of your property from your name to the trust. It's a crucial step that requires careful attention to details to avoid any potential legal hiccups. Afterwards, we discussed the importance of storing the trust document. This might seem like a minor detail, but it's a crucial one. The trust document is a legal instrument that needs to be kept in a safe and secure location. It's not something you simply file away and forget. It's the key to your trust and should be treated with the utmost care. Throughout our journey, we reiterated the benefits of putting property into a trust. From potential tax benefits to the ease of transfer upon death, these trusts offer a level of control and security that's hard to match. By setting up a trust, you're not just planning for the future, but ensuring that your wealth is protected and distributed according to your wishes. By following these steps, you can successfully put your property into a trust and enjoy the benefits it offers. Thank you for watching.